Yes, good morning, Mr. Firth.
Good morning. I was at the critical point in Frank A. Smart behind tab 16, page 184, paragraph.
Thank you. Yes.
Sorry, can you use the page number again?
184, my lady. So Lord Hodge, on behalf of the Supreme Court, begins, more recently, the CJU has called into question its ruling in the BLP in the light of its developing jurisprudence. So just pausing there, what the Supreme Court is saying is it's called into question its ruling. And you'll remember yesterday, if we please go back to paragraph 28 of the same judgment, the ruling is, as you'd expect, the ultimate conclusion, as quoted immediately prior to Lord Hodge calling it the ruling. So thus it held at 28, and then that key, the passage my learned friend relies on, that if it's attributable to exempt supplies, can't recover, doesn't matter, the ultimate purpose is carrying out the taxable transaction. That's the ruling in BLP. And you'll note Lord Hodge distinguishes the ruling from the reasoning, because in the next sentence, he goes on, it's clear that this ruling in terms relates only to the use of service for exempt transactions. That's the ruling. But as HMRC set great store by this case and submit that it's reasoning. So the reasoning is the steps along the way. The ruling, as very clearly, 28, paragraph 28, as quoted in 27. And so when we see it, paragraph 41, Lord Hodge saying it's called into question its ruling, it's called into question the overall result in that case. And so when my learned friend says, well, no one's ever suggested that BLP is being called into question or disputed, well, that's not right. Right there.
Ruling paragraph 27, isn't it?
So the ruling is quoted at the end of 27,
Yeah.
and then in 28, Lord Hodge says, refers to that as the ruling, and then he distinguishes that from the reasoning. The ruling wasn't relevant to, it didn't apply to HMRC's case in Frank A. Smart, but HMRC said, well, the reasoning helps, as they're trying to carry that across it. And so when we see at 41, called into question the ruling, that's what I've just referred you to. And then it says, in the light of its developing jurisprudence, attributing input expenditure on the raising of capital to the general overheads of an undertaking. So this is a specific development, specifically in relation to the raising of capital. It's not a general development. It's not saying that chain breaking effect doesn't normally apply. It's saying there's a development of the jurisprudence specifically in relation to raising of capital. And that's why it's meaningless for HMRC to point to other cases that don't concern the raising of capital and say, look, they've just applied the normal chain breaking effect of an exempt transaction. So be it. The development doesn't relate to that situation. So, for example, my learned friend refers to Royal Opera House. Didn't even consider SKF. Certainly wasn't in any way concerned with raising capital. So already we're on notice that the actual result in BLP is being called into question. Why is it being called into question? Because there's developing jurisprudence in relation to raising of capital. We're already on notice about that. And then you have Lord Hodge summarizing the facts of SKF. You've already seen the facts, but Lord Hodge was clearly aware of them. And those services were all clearly directly linked to the share sale, negotiation, valuation, drafting. We then see at 42 a summary of what the Advocate General decided in SKF. In the first part of that paragraph, Lord Hodge tells us that Advocate General endorsed the distinction between the chain-breaking effect of an exempt transaction and the absence of such an effect where the fundraising transaction is outside the scope. So that's exactly what I was talking about yesterday. That's where the problem lies. That's where the difference of treatment lies, in the sense that if it's an exempt supply of shares, then it blocks the input because it breaks the chain of causation, chain of attribution. If it's outside the scope, it doesn't. And what we're being told here is correctly, the Advocate General endorsed that distinction. And then in the second part of paragraph 42, he opined that where the taxable person acquires supplies of services in order to carry out a share disposal, so these are supplies used in the share disposal. We'll see that again in a minute. So we'll go to the Advocate General, which is an exempt transaction. He does not have the right to deduct input VAT on those services. That is HMRC's case. Yesterday, HMRC attempted to argue, well, there's something very subtle in the Advocate General's opinion that the Court of Justice disagreed with. But that's not right. And we're going to go to it in a moment. But just to see this summary here, Lord Hodge is telling us in very simple terms, the Advocate General raised and approved the chain-breaking effect, and then the Advocate General applied the chain-breaking effect. There's nothing subtle about that. That's just the ordinary chain-breaking effect. And if we could go to the Advocate General, we should see what the Advocate General says. There's nothing subtle about it. It's just the ordinary chain-breaking effect as applied by the Advocate General. So it's tab 28, and it's page 415, please. And we can see at the bottom of page 415 in paragraph 59, the third question. It's clear both from the wording of the third question and from the reasoning set out by the National Court. The National Court seeks to know whether, although the expenditure incurred in the acquisition of supplies, the input transaction is directly linked to the share disposal. So that's our premise. It is directly linked to the share disposal. There may nonetheless be a right to deduct input VAT to the extent that the expenditure forms part of the taxable person's general overheads in the overall context. And he then observes that that's because it's carried out in the context of a wider restructuring. So the Advocate General is specifically identifying the question of where the supply is directly linked. Not some sort of broader notion of, well, there is a category of supplies that relate to, and some may be directly linked and some may not be, and those latter category are treated in some special way. It's specifically, directly, only the directly linked supplies. So that's the question, and that's what the whole opinion is about. At 63, please, we see the Advocate General referring to the facts. In the main proceedings, the National Court has made the finding of fact that the services acquired by SKF are directly linked to the disposal of shares in the subsidiary and in the control company. Those services deal with the valuation of the shares, assistance in negotiations, drawing up contracts, and were therefore acquired in order to carry out that disposal. So when you see that phrase, supplies in order to carry out the disposal, that just means these supplies which are directly linked to the sale of the shares. There's no wiggle room, there's no subtlety here, it's just straightforward. Those supplies are directly linked, you found that, and frankly it's obvious. Just below E, correctly therefore, the referring court, the Skatteverket, the government which submitted observations, and the Commission also consider, in light of the findings of fact made by the National Court, that there is a direct immediate link between the input services and the disposal of shares. So we're not dealing with supplies that aren't linked with the disposal of shares, or any ambiguity about that. They are. And then we have the short answer. The disposal of shares being, as I suggest in the answer to the second question, a transaction which is exempt, the VAT payable on the supplies in order to carry out those transactions cannot therefore in all logic be deducted, since the services constitute part of the costs of the exempt transaction. Which is the straightforward answer my learned friend says should be given in that situation. There's no wiggle room, there's no subtlety about it. My learned friend says, if they are directly linked to the share sale and the share sale is exempt, no recovery. It's not that there's something further to argue about or investigate there. No possible facts that we need to look into. We know the facts. Relevant. And you can see at 65, the Advocate General says, basically, that's what was decided in BLP. That, moreover, was the conclusion reached by the court in BLP Group. The court held that VAT payable on professional services acquired by BLP Group in connection with the disposal of one of its subsidiaries could not be deducted since the services in question had been used to carry out the exempt transaction. So this is the straightforward chain-breaking effect analysis that HMRC advanced in this court. And it becomes more explicit. So at 66, the court has also stated that the rule applied even if the ultimate purpose was carrying out a taxable transaction. So that's BLP. 69, as was very appositely pointed out by the Advocate General in Abbey National, it is therefore clear from BLP that the VAT chain-breaking effect, which is an inherent feature of an exempt transaction, will always prevent VAT. So no subtlety, always prevent VAT incurred on supplies used for such a transaction. My learned friend agrees entirely with that. That is her case. And if she doesn't agree with it, then I would respectfully say that we need to understand in what way she doesn't agree with it. Because as I understand it, my learned friend says, if you use the supplies for an exempt transaction, that will always prevent VAT being recovered. The need for a direct and immediate link thus does not refer exclusively to the very next link in the chain, but serves to exclude situations where the chain has been broken. 70, again, repeating, it seems to me that the conclusion reached in BLP Group and the reasoning behind it, as set out above, may validly be transposed to the present case. At 73, the Advocate General distinguishes the cases where deduction has been allowed. The relevant judgments in which the court has recognized the possibility stated in point 71 of deducting input VAT related to transactions which, contrary to the premise on which the BLP Group judgment was based, were linked with output transactions which fell entirely outside the scope of VAT. You see the emphasis. Because they were not considered to be either suppliers of goods or suppliers of service, and which accordingly were irrelevant to the determination of the right to deduct. It was therefore permissible in those circumstances to look not only one or more output transactions which might arise, but also therefore, where appropriate, links with the general economic activity. So he's explaining the other cases in the way my learned friend explained them. 76, with reference to Kretz Technic, it appears to me that the court accepted the distinction made by the Advocate General in his opinion between, on the one hand, outputs which were exempt from payment of VAT and those which escaped VAT by being outside the scope, because the latter cannot be deemed to be either supplies of goods or services, and also confirm the decision made in BLP, in which, moreover, the Advocate General's argument was based. And then the Advocate General notes, you might say, well, this means that it's treated more favorably if the share sale is outside the scope. So the approach outlined above, which seems to me to be that adopted in the case law, may appear to treat the share disposal transactions which fall outside the scope of VAT more favorably than those which, although within its scope, are exempted. Whereas the right to deduct may arise on services acquired to carry out a transaction outside the scope, when such services are regarded as directly and immediately linked to general economic activity, for the taxable person, the VAT payable on services acquired to carry out an exempt transaction, on the other hand, cannot be deducted. Again, my learned friend says that is unimpeachable, never touched, remains the law.
Can I just pause you there?
Yes.
I don't know if you're going to look at footnote 40, which is the caveat to that statement, which seems to raise the possibility that you could have a share sale characterised as a transfer of a going concern, which would then put you into a de-supply scenario. In other words, you'd ignore it for VAT purposes. Even though it might otherwise be exempt, you could TOGC it and that he seems to accept there is that possibility that you could find your way through that way.
Well, in that case, the share sale is not an exempt supply, it's an outside
Right,
scope.
exactly. That would then put you into a world of, I suppose, it's abinational, if that's the case.
Yes, yes. If you could fall within that approach, then you would be outside of the BLP case, and you would be inside the Kretz Technic case, or the abinational case.
So what he says is if you have that exactly, I think this will, I found the footnote quite difficult to understand, but I think what he says, it's right in the last couple of sentences, in that sort of case, the services acquired to carry out such a transfer would be directly and immediately linked to the general economic activity.
Because it's a
So
transfer of a going concern.
Yeah, exactly.
Yes.
So that is, it's just, you know, there is that wiggle room, I suppose he's saying.
It's not wiggle room. It doesn't in any way detract from what he's saying about the chain breaking effect. Because in that case, if that situation arises, then by definition you haven't got an exempt supply of shares anymore.
No, I think we're on the same page.
So it's just the idea of wiggle room.
With each other, but he is just saying there is this other possibility because there's a lot of it was the earlier questions I think have been all about. There had been I think a question or there'd been some debate about Article 5.8 and TAG.
Yes, in fact, in the First Tier Tribunal here, we said, well, this can be treated as, and the First Tier Tribunal said no. It's not quite clear when that transfer of going concern treatment applies. We're told it doesn't apply here. We haven't appealed that. But if it does apply, it's not an exception to what we're talking about.
But it would get you home, wouldn't it?
It
That
would
be another way of getting you
if
home.
you could, but it just doesn't seem to apply. And we said it applied here. We were told it doesn't. I'm not sure when it does apply. But if it does apply, it's not an exception. It doesn't call into question BLP. It is merely the application of BLP having properly characterised what's happened as a transfer of going concern, my lady. So again, there's nothing here that my learned friend disagrees with on the submissions yesterday. There's no subtlety in terms of the chain breaking effect if it is an exempt supply of shares. And as I was saying, 77, the Advocate General identifies the more favourable treatment. This is exactly what was picked up at 66 in the Court of Justice. And whereas the Advocate General says, well, that is just what the law is, and in fact he says, well, actually they're not similar. We'll see that in a moment. The Court of Justice takes the opposite view and says, well, actually these are similar. They shouldn't be treated differently. And here's the remedy. And of course, this is a stage 1 issue. The distinction between these two situations arises only at stage 1. There's no difference at stage 2 if you get there. And at 78, the answer I just mentioned. However, that situation is no more than the consequence inherent in the common system and in the dividing line, which must be drawn as clearly as possible between taxable transactions on the one hand and exempt transactions on the other. Hence the direct and immediate link test and the breaking of the VAT chain when an input transaction on which VAT is payable is directly and immediately related to an output which is exempt. As I said, my learned friend agrees with everything in there. The reasoning is as Lord Hodge describes in paragraph 42, and if we could go back there now that we've seen very clearly in my submission what the Advocate General was saying, we can go back to 42 and acknowledge in my submission that's entirely accurate. The Advocate General was simply saying the chain breaking effect of an exempt transaction, and here we have an exempt transaction, therefore we must apply that. No subtlety. So if we could return, please, to tab 16, Frank A. Smart, page 184. And in paragraph 43, having just set out what the Advocate General said in summary, and we've just seen it in more detail, the Court of Justice disagreed with his conclusion in relation to an exempt transaction involving a sale of shares in circumstances which were analogous to the facts of the case. So that's the case, that's the facts of SKF. Now, on my learned friend's interpretation, where is the disagreement? there is no disagreement. Because my learned friend says SKF changes nothing. SKF in particular reaffirms the chain-breaking effect of an exempt transaction. And that is all Advocate General Nugee was doing. Here we have the authoritative interpretation by the Supreme Court telling us no. Whatever the Advocate General said, which is summarized in 42, the CJU disagreed with that conclusion on the facts of that case, which involved an exempt sale of shares. And then it held at paragraph 73 that there was a right to deduct input VAT on services acquired for the purposes of a disposal of shares if there was a direct and immediate link with the costs, between the costs associated with the input and the overall economic activity. So pause there. This is the point I made yesterday in relation to 73. There is a right to deduct input VAT paid on services acquired for the purposes of a disposal of shares. So these are services that are directly linked on the ordinary test to the sale of shares because they are acquired for that purpose. And we know that on the facts because we know what the services were: valuation, negotiation, drafting. But nevertheless, instead of saying there's a chain-breaking transaction in the middle, the Court of Justice, we are told, and we saw it yesterday, is that even though they acquired for the purpose of the disposal, if you can establish a direct and immediate link with the overall economic activity, you can recover. Now, my learned friend's interpretation, that's an impossible sentence. It just amounts to fundamental contradiction. Because on her case, well, if it's acquired for the purpose of disposing of shares, you can never have a direct and immediate link to the general economic activities. So that just is meaningless contradiction. It held that the referring court should take into account of all the circumstances surrounding the transaction to determine whether the costs incurred were likely to be incorporated in the price of the shares sold or whether they were among only the cost components in the transaction within the scope of the taxable person's economic activities. So that's the wording we saw yesterday. As I explained, you have to apply that, having applied the modification at 68. We'll see the Supreme Court talks about that in a moment. At 44, the Supreme Court begins setting out the reasoning. So again, there's a difference, it's a consistent difference throughout the Supreme Court decision between a ruling by the CJU and its reasoning. We're talking about the reasoning here. The reasoning on the way to this conclusion is instructive. And then my learned friend showed you 1 to 4, Roman 1 to 4, and then we get to my submission 46. And this is critical. There's no wiggle room in this paragraph in my submission. Applying this reasoning to the circumstances of SKF's proposed transaction, CJU advised that the referring court will have to ascertain whether the costs incurred were likely to be incorporated in the price or whether they were only cost components of the products. Paragraph 62. Well, that's picking up what you saw at the end of 43. It referred to the cases I've discussed. So this Midlands, Abbey National Securenta, acknowledging that they concern financial output transactions which were outside the scope. But it went on to observe that the main difference between an exempt share sale and a share sale which was outside the scope was whether the taxable company was or was not involved in the management of the companies. There was therefore a risk of infringement of the principle of fiscal neutrality through treating objectively similar transactions differently for tax purposes. There's a very real danger of me doing this point to death, but what is the difference in treatment? It's that stage 1 difference, that if it's an exempt transaction, you have the chain breaking effect. Supreme Court's telling us that that chain-breaking effect, A, was rejected by the Court of Appeal, that didn't agree with the conclusion, and now is telling us in detail how it disagreed. It held at 68 that if the costs relating to the disposal for shareholdings are considered to form part of the person's general costs in cases where the disposal itself is outside the scope, the same tax treatment must be allowed where the disposal is classified as an exempt transaction. So that's the holding. That's the key point. It held. Paragraph 68. If the costs relating to disposal would be general costs if it was outside the scope, treat them as general costs when it's exempt. As I said yesterday, it's not automatic. It's only if, in the counterfactual world where this was an outside the scope share transaction, you would have treated them as general costs because they are for the purpose of raising funds for the general economic activity. If that's satisfied, then you apply the same tax treatment. What is that tax treatment? Treating them as general costs to the exempt supply situation. And then, to put the point beyond doubt, just above G, in my view, it is implicit in the Court of Justice reasoning that it accepted the distinction which the Advocate General made in his opinion in Abbey National and Kretz Technic. What is that distinction? It's the distinction between the chain-breaking effect of an exempt supply and the not chain-breaking effect of an outside the scope. Okay, so it implicitly accepts that, but recognize the need to modify the result. What is that result? It's the result of the chain-breaking effect. It's the result of the stage 1 problem. Recognize the need to modify the result for the purpose of VAT of an exempt initial transaction in order to avoid discriminatory fiscal treatment. In my submission, it couldn't be clearer. It could not be clearer there that the problem is the chain-breaking effect. The Court of Justice has said we need to modify the result of that chain-breaking effect. When do we do that? We do it in the circumstances described in paragraph 68 of SKF. I'm not going to repeat that.
Could you just formulate for me, I'm going to ask Ms. McCardle the same thing when she comes to the
Yes.
I mean, maybe we need to be really clear about what is the modification.
Yes.
What is that modification? Can you just give me your encapsulation of last proposition, which is the CJU has recognised the distinction, and you call that the chain-breaking point, got that on board, but has also recognised the need to modify the result. What is that modification?
So let me just be clear about the result. The result is that if you have an exempt supply, you have the chain-breaking effect, you get no recovery, you don't get to stage 2. The result in the outside the scope is you don't have a chain-breaking effect, you do get to stage 2, and it will be general costs if it's for the purpose of raising funds for the general economic activity. What is the modification? It's in the preceding sentence. If counterfactually this disposal of shares had been outside the scope, and if in those circumstances, on these facts, it would have been treated as general costs, i.e. you get to stage 2 and you can recover it as general cost, then the same will apply, must apply, even though it's an exempt transaction.
So the modification of result is that you get your input tax back as if it was an outside the scope share sale.
Yes, but only if, had it actually been outside the scope, you would have got recovery. Yes.
As if it had been.
Yes.
As if,
I mean, the result is either...
Sorry. Clarity, fewer words. I just need to really strip it down, please. So that's the modification of result, that you do get your tax back,
Yes.
because in the analogous world, if it had been an outside scope share sale, you would have been able to get your tax back at stage 2 there. So that's the modification of result.
Yes.
How does that live with the first bit, which is the Abbey National Kretz Technique distinction between the chain breaking distinction, saying that if you have an exempt supply, you don't get the tax back. In other words, is he really talking about a modification of result or a modification of analysis? He's saying that you don't treat this share sale, which is exempt, is for these purposes treated as outside the scope.
No, you don't. I mean, it may be a difference without distinction. He's not. The Court of Justice wasn't saying you should treat that as outside the scope. It was saying that you should allow recovery in relation to the exempt transaction, acknowledging it is an exempt transaction, but on the basis that had it been, counterfactually, had it been outside the scope, you would have. So it's the result that's modified in the sense that you go from not recovering to recovering. That is the result. But only if, counterfactually, you would have recovered if this had been outside the scope. So it's not deeming it to be outside the scope, it's just saying, well, if we analyse it on the assumption it had been, what would the result have been? And you get the same result.
Okay, so I've written down this. The modification is of result. You do get your tax back on the inputs, related inputs, if you would have recovered those inputs in the analogous situation where the share sale was outside the scope. Something like that.
Yes. And then that's why it's not automatic. That's why you then have to go to Kretz technique and apply that reasoning as to, is the purpose of this to raise funds for your general economic activity?
I mean, I understand the way in which you put it, but I have not understood how that is to be squared with what the Court of Justice says, both in 62 and in its dispositive. In 62, it says, we can't tell from the case file whether there's a direct and immediate link with the initial transaction or with the general economic activities. And they say, that's a matter for the National Court. And they say, in order to establish that, you have to look at where the costs are likely to be incorporated. And they come back to that in their dispositive. Well, they do it in 72.
You've got to apply that wording with the modification. I mean, the Supreme Court makes it very clear at 46. It starts off with that wording my lord just referred to.
Yes, but why does the CJEU send it back to the referring court saying you've got to decide whether the direct and immediate link is with the exempt initial transaction or whether the direct and immediate link is with the general economic activities. And for that purpose, what you need to look at is whether the costs are likely to be incorporated in the sale price on the initial transaction or whether they're likely to be only part of the general economic activities and general overheads. Because your argument seems to be you don't look at that. You don't need to look at that question. If you've got a case like ours, or in a case like SKF, where the initial transaction is exempt, you modify that, and as long as the purpose is to raise capital for your general economic activities, then it is attributable to overheads in the same way as it would have been if it had been an out-of-scope transaction. And that doesn't seem to involve any inquiry as to where the costs are incorporated. But that is the question that the CJU sends back to the Swedish court and tells it that it must determine.
But
Why? Why does that
First,
happen?
my lord, as I showed you, and it's consistent, the Court of Justice cannot apply the law to the facts. So even in cases where it's obvious what the answer is now, you don't come back, the Court of Justice will not in terms say, and now the answer to this case is as follows. It always sends it back with its guidance on the law. In terms of why is that wording still there, it's there because it's not automatic. 68 is not automatic. You have to consider what the situation would be in the counterfactual, and then the effect, if you have a counterfactual where it would have been recoverable if outside the scope, the effect under Kretz technique is that therefore you treat it as part of the cost components of the general activity. I showed you that in 36 of Kretz Technique yesterday. And I emphasized, please bear this in mind, because this is the treatment that the Court of Justice is carrying across where 68 applies. We can go back to Kretz Technique just to see that it does.
No, I understand if you've got an out of scope, if the initial transaction is out of scope,
Yeah.
then you don't treat the costs incurred on the initial transaction as cost components of the out of scope transaction, because the out of scope transaction is just out of scope. So the costs become part of your general overheads. I understand all that. What I don't understand is where your initial transaction is exempt, why, on your analysis, the CJU tells you you have to decide what the cost components are, costs of, where the costs lie. I mean, that is what they've told the National Court to determine. And I don't understand it, because on your analysis, once you conclude, as was found in the SKF case, that the purpose, the ultimate aim of selling the subsidiaries was to raise capital for your general economic activities, then on your case, it follows axiomatically, as a matter of law, not as a matter of fact, that the costs of that are treated as cost components of your general economic activities. And therefore, there's nothing for the referring court to answer. It answers itself. And that's what I'm struggling with. Why does the CJU say this is what it turns on, when in your case, it doesn't turn on that at all?
It absolutely does turn on that, but with following through the modification, because the end result of Kretz Technique is you treat them as cost components of your products as a whole. That's the end result. That is the Kretz Technique treatment. I showed you this at 36. Perhaps it's worth going back to that.
No, I understand that. I still don't understand why they've asked the referring
Court
court.
of Justice, it says it, paragraph, I think it's 63, it says, we cannot answer the question for you. And even in cases where it's blindingly obvious what the answer is as a result of the interpretation of the court will still say, it's now for you to apply the law to the facts, even if the answer is blindingly obvious.
This case, they say, it's very clear, I think it's 60 and 61, or it might be 61 and 62. They say that the national courts made a finding that these inputs are attributable both to the share sale and to the general overheads. And then the next paragraph it goes on to say, that is not a possible conclusion. So this isn't the ordinary case. This is like, and then they say that the case file is a mess. And they say more than this, it's clear they were pretty dissatisfied with the way the reference had come to them. So that's the background to them saying, isn't it? That's why they send it back. It's because they can't make sense of the court's findings.
My submission, the answer is they send it back because they have to. They don't know how to answer it. I mean, you look at this the opposite way. So my Lord's point is, well, if I'm right, why didn't the court just tell us what the answer is in very simple terms? The answer being, yes, you can recover because X, Y, and Z. Well, that's my learned friend's case.
Why doesn't the court say, on your case, why doesn't the court say, we have to send it back, you can't make decisions on the facts, and you've got some funny fact findings here. But the question for the National Court is whether, in an analogous fundraising situation where you had an outside the scope sale of shares, as is illustrated by a case like Kretz Technique, is this case analogous to a case like Kretz Technique? That's what that's the question that should have been directed. They should have said, think about this harder. And if you've got a case that is an analogy with cases like Kretz Technique or Abbey National, so if this share sale had been outside the scope, would there have been an entitlement to recover at stage 2? And if the answer is that there would have been, hypothetically, an entitlement in that analogy, then the right to deduct exists. Something like that.
That is what they say, and that's what the Supreme Court says they're saying. At 46, they set out the wording that we've just been discussing and said, well, it could have been clearer. But then the Supreme Court immediately goes into the point about the difference in treatment, and then immediately into paragraph 68 as being the answer and the holding. It says, it held. it held that is the key finding, and we'll see that in the Supreme Court later summarizes this, and it refers again to 68. 68 is critical. It is the holding. It is the thing that tells you that you need to consider what would be whether these costs would be general costs if it had been outside the scope, and if they would have been, then you treat them as general costs in relation to an exempt, and if you do that, then the wording at the beginning of 46 is satisfied in the taxpayer's favor. Now, could it have been made clearer? Possibly, but indeed probably. But 46 is the Supreme Court grappling with the same problem this court is grappling with and telling us what the answer is.
Can I pick up a submission you made earlier? You said paragraph 68 of it's not automatic. You have to consider what the situation would have been in the counterfactual.
Yes.
By the counterfactual, do you mean assuming that the supply of shares had not been exempt but had been outside the scope? Is
Yes.
that what you mean?
Yes. That's what 68 says.
No, there's no 68 doesn't use the word counterfactual. I wanted to understand what your submission was. Counterfactual means assume
Well, it says
the initial share sale is outside the scope. Yeah.
yes. Well, the Supreme Court says it held if the cost are considered part of the general cost in a case that's outside the scope, the same tax treatment must be allowed where it's classified as exempt. So the if is the counterfactual. It doesn't say counterfactual, but the if is requiring you to consider the alternative situation. And then we get to the modification result, which is clear beyond peradventure. And all the points the court has just perfectly rightly asked me about apply to my learned friend's case with even more force. Even more force, because on her case, this is a very simple case. It's a very simple question because we've already answered it in PLP. The answer is very clear that these, if they are directly attributable to the share sale, that is the end of the question. Do not go on and consider whether they are used for the general overheads or for the general activity. It's a very clear answer. And we don't get that clear answer. Instead, we get all the points that are discussed in paragraph 46. So I accept that things could have been explained clearer. That's often the case with the Court of Justice. But on my learned friend's case, none of this makes any sense at all because there is no modification of any result. And that's in my submission, unarguable. On her case, there's no modification of result. Because if it's used for an exempt share sale, as was the facts, you never get to stage 2. And in fact, there was never any difference in stage 2 anyway. And it's just abundantly clear. We've been through the Advocate General. The Advocate General is emphatically applying the chain-breaking effect. That's all the Advocate General is doing. We've seen the Supreme Court say that's what the Advocate General is doing at 42. We've seen the Supreme Court say the Supreme Court disagreed with that. And then we've seen in explicit terms of 46 how it disagreed with it, modifying the result of what? The chain-breaking effect. So yes, it could have been clearer, but frankly, we've got the Supreme Court telling us the answer. And on my learned friend's interpretation, this is all wrong. It doesn't make any sense because there's no modification. And this is the point the Upper Tribunal made, is we just cannot read these paragraphs in any other way. So it's one thing to say, well, couldn't it be, on my case, couldn't this all have been a bit clearer? It's another thing to say, but here's another, even clearer explanation of all this that leads to the opposite result. But there isn't one. There's just no other way of reading this. So whatever difficulties this court has, there's no alternative. Certainly no alternative that's clearer. And as my lady said, my learned friend needs to. I haven't understood what modification my learned friend said exists, and that's a critical question. 47. My learned friend seemed to criticize me yesterday. I've failed to deal with this in some way, but HMRC don't even mention this paragraph in their skeleton, so I'm not really sure what that criticism amounts to. But in any event, it confirms what I've just said. So, Lord Hodge says, It's important to consider further the statement of paragraph 59 of the judgment. Summarised above, that's point 4. It was that, in contrast to the circumstances where the cost of services follow a taxable person's general costs and components of the part of the goods and services which he supplies, where goods and services acquired by a taxable person are used for the purposes of transactions which are exempt or do not fall within the scope of VAT, no output tax can be collected. In order to be consistent with the Court of Justice reasoning outlined above, paragraph 46, that statement, when applied in the context of a fundraising transaction, such as a sale of shares, must be a reference to the downstream transaction for which the input costs form a cost component, not the initial fundraising transaction, unless the cost of the input was a component of the price of the shares in the initial transaction. Key point is, in the context of a fundraising transaction, that doesn't necessarily mean the fundraising transaction was for the purpose of the general activity. So you still have to go through that Kretz-Technic analysis to say, well, look, we've got a fundraising transaction here. That doesn't mean you get recovery. We've got to look at the purpose of the fundraising transaction. And it's only where the result of the counterfactual would have been overheads that you treat it as overheads in the case of the exempt sale. So there can be cases, indeed there will be cases, where you have a fundraising transaction by way of an exempt sale of shares, but the purpose of the fundraising is not to raise funds for a general taxable economic activity. In that case, even if you'd applied the outside the scope type analysis, you would not have got recovery. Therefore, applying 68 of SKF, you do not get recovery under the
You're entered there, aren't you? You have to look at what the outputs are, and they might be a mixed bag. And if they're a mixed bag, so if they're wholly exempt,
the downstream, yeah.
Stage 2.
Or it could be entire. You could be saying we're going to raise money to buy shares in a company, and we're not going to manage it, and that just is not in any way related to your taxable economic activity. So there's nothing in 47 that's inconsistent with what I said. In fact, it supports it. My learner friend obviously tries to focus on the last words, but that's just because we haven't specified whether the fundraising transaction was raising funds for the purpose of a taxable economic activity or not.
But what do you say about those last words?
Well, they're correct, because it's only if the fundraising transaction was for the purpose of a taxable economic activity that you would treat them as incorporated into the overheads rather than just leaving them where they lie as being directly linked to the share sale. So that's what I'm saying. 68 is conditional upon what would have happened if it had been outside the scope. And if in the outside the scope situation you wouldn't have got recovery, you don't have a modification, and therefore you would leave those costs as being directly attributable to the share sale. And then you'd fall within the last wording of 47. On the other hand...
So for last, can I get this straight?
Of course.
You say the last word, the unless bit,
yeah.
in 47, you have to understand that as saying that only applies where on the counterfactual hypothesis you've got a business that in fact makes exempt general outputs. So you don't get any of that.
No. It's in any situation where you don't satisfy paragraph 68.
Formulate that proposition. I need to get it down.
Of course.
Focus on the last words. They're correct, those last words, only if.
Well, no, they are correct, not only if, but they will only be satisfied if paragraph 68 is not met. Because if we just take this in stages, the starting point, always accepted, is on the traditional normal analysis, these inputs are directly linked to the share sale. And the share sale is exempt. The modification in paragraph 68 applies where counterfactually, in the outside the scope, those same costs would have been treated as general costs. So it's only if that condition in the counterfactual is satisfied, that we treat these costs as not being directly linked to the share sale, but instead being general costs. And therefore, even though you've got a fundraising transaction, depending on the purpose of that fundraising transaction, the modification may or may not apply. And if it doesn't apply, then there is no alteration to the basic fact that those costs were directly linked to the share sale. The alteration only applies, modification only applies if the condition in 68 is satisfied. And so that would be the difference between a fundraising transaction for something that isn't taxable activity, and there can be any number of that. It could be an exempt activity, it could be a outside the scope activity, it could be private activity. It could be a number of reasons why the fundraising transaction does not satisfy the condition in 68. And then that's when those last words bite and say, well, there's no modification, so you're stuck with the result that these are directly linked to the share sale.
So do you read, unless the cost of the inputs was a component of the price of the shares in the initial transaction, as if it meant the same as, unless in the circumstances there is a direct and immediate link between the costs and the initial transaction? I mean, is what Lord Hodge is referring to there, the cost of the inputs being a component of the price, simply another way of saying there's a direct and immediate link?
Yes, I don't disagree with what my learned friend was saying about most of that yesterday. Yeah, there's a number of different ways, and in Midland Bank, the court sort of said, look, the best we can do is direct and immediate link. There's various different ways of expressing that. But yes, cost component is another way of saying direct and immediate link.
Thank you.
And that's why we have to apply the modification recognized in the end of 46 to deal with that properly.
So as I understand the way we to look at the unless thing, we're in the context of a fundraising transaction, so it would read something, fully to understand it, you'd need to read it as something like, unless the fundraising transaction in question is for an activity which is not taxable, in which case the cost of the inputs will be a component of the price of the shares?
Yes. Yes. Because in that situation, you don't modify the original position. You don't modify the result. And so they're left where they originally were. Yes. 48, Lord Hodge says, it's noteworthy that the cases referred to at 59 did not involve initial fundraising transactions. So his lordship's point there is that they were simply describing the general position, not the position for initial fundraising transactions. It's in light of the subsequent reasoning that we get the modification. And it's fairly startling on my learned friend's case that actually BLP is not mentioned at all by the Court of Justice in its answer to question 3. It's not mentioned at all. Whereas on her case, that is the answer, and the court's approving and reaffirming what it's already decided. It's not mentioned. And then at 49, so we've already seen the Supreme Court said it called into question its ruling in BLP, in SAF, and now you'll remember that what HMRC were trying to do was to extend BLP to outside the scope fundraising. And we see here Lord Hodge saying, well, that's not right, and in fact, the reverse is true. BLP doesn't even apply to exempt fundraising transactions. So it says, in my view, it is clear that in SKF, the Court of Justice has not extended the reasoning of the LP to apply to fundraising which is outside the scope. On the contrary, in order to avoid discriminatory treatment, it has extended the reasoning in the cases about share disposals that are outside the scope to share disposals which are exempt, by requiring an examination as to whether the costs are incorporated in the price of the shares or in the price of the taxable person's products. If the latter, they would be among only the cost components of the transactions within scope. So this is, again, this is the fourth time now we've been told that the Court of Justice has done something fairly important. What has it done? It's extended the reasoning in outside the scope cases to exempt cases, which is the opposite of what HMRC were trying to achieve.
It does look, I mean, this reverting to a point I made earlier, as if Lord Hodge had understood what the Court of Justice had done, is to require an examination as to where the costs are incorporated, as if that's a factual question, whereas on your submission, and I think on Miss McArdle's submission, it's not really a factual question at all. It's really a legal categorization. The way you put it is, if this is a fundraising transaction of the type that would qualify as overheads for general economic activities were the initial transaction out of scope, well, then it follows that the costs are to be treated as components of your general outputs. So it's not really an examination of that question at all. Lord Hodge appears to have read it as if there's some factual question for the referring court, for the national court, to investigate. But I don't think you think that's right.
Well, there is a factual question, but it's not the question of where do you recover these costs, which output do you say, right, we're going to recover this by increasing that price by X. That's, I agree, not the inquiry. But there is still a factual inquiry, which is the one my lord described. I cannot look into Lord Hodge's mind and tell you whether he understood that. I have to assume he did, as representing the opinion of the Supreme Court that considered this in some detail. So extended the reasoning from outside the scope, which is exactly what I've been saying. Whereas my learned friend says, that, I don't know how my learned friend explains that, because in her analysis, the reasoning in outside the scope just doesn't apply, because you will get the chain breaking effect. And what is that reasoning? Was the Kretz-Technic reasoning? We've already seen that. And in fact, we can go back to paragraphs 37 and 38 of this judgment, where Lord Hodge tells us what that reasoning is by reference to Kretz-Technic. So at 37 on page 181, the CJU's judgment on the deductibility of VAT on services provided to Kretz-Technic is wholly consistent with the AG approach in its disregard, that's the reasoning, disregard for initial transaction which is outside the scope. And at 38, the CJU, disregarding the share issue itself, held that you could attribute the cost to the downstream activities. So that's the reasoning referred to at 49. That is the reasoning that carries across. It's the disregard of the initial transaction.
Can I just go back to a question that my Lord of Justice Nugee asked you moments ago about the nature of the inquiry? The tribunals in this case seem to have thought they did have to make some kind of factual inquiry about how the costs were made up.
My lady, I'm coming to that with respect.
Oh, I'm sorry.
Well, no, my lady, it's a good question. It's one I definitely need to pick up. It's not right what my learned friend said. The First Tier Tribunal directed itself specifically by reference to VWFS, that where or how you recover the cost is not determinative. All it says at 46 is, well, look, even if we did look at that factual question, it doesn't help you, HMRC. And then at the end of the 46, it makes the relevant point, which is the purpose of this was to raise funds.
Okay.
The First Tier understood exactly what it was doing. It had VWFS firmly in mind, and with respect, my learned friend's presentation wasn't accurate. I'm coming to that later, though.
All right, I'm so sorry. I don't want you to deal with it out of turn, and it may be that I haven't read their decisions carefully enough. So thank you.
I will demonstrate that later, if I may.
Okay, thank you.
In fact, very soon, given the time. The Supreme Court then goes through lots of other decisions, including Sveda. I'm not going to trouble you with those. You need only notice that this is an exhaustive consideration of the case law in this area. In fact, if you look above, I think it's 27, the Court of Justice, sorry, the Supreme Court says on page 177, Section 2, the disputed case law. Why is that important? Because then when we come to Section 3, just above 65, page 191, summary of the case law. So this is a summary of the case law it has just exhaustively been through. And the Supreme Court says, I derive the following propositions which are relevant to this appeal. Proposition 1, I don't think it's controversial. Proposition 2, there must be a direct and immediate link between the goods and services which the taxable person has acquired, in other words, the input transaction, and the taxable supplies which the person makes. In other words, its particular output of transactions. This link gives rise to the right to deduct. The needed link exists if the acquired goods are used for the purpose of the person's taxable transactions. The key point is this is the modified stage 1.
What's modified about it?
You only ask if there's a direct link with taxable supplies. That's what it says. Do not ask, as my learned friend says, is there a direct link with taxable, exempt, or something else? It says, ask if there's a direct and immediate link between the goods and taxable supplies.
That person makes, in other words, it's particular output transaction or transactions. Isn't it talking about specificity of allocation here?
No, it's the only question you ask is whether there's a link with taxable supplies.
Which that person, how do you explain the rest of that sentence?
Because it's just telling you what the taxable supplies would amount to. And then it repeats the point later. The needed link exists if it's a component of your taxable transactions.
So just to be clear, you say that that's not a reference to particular or specific outputs.
But it
incorporates any sort of taxable supplies, whether they're the particular ones or they're the general ones.
No. This is my lady's right. This is the question of whether there's a specific link.
Okay. Good.
But it's only asking if there's a specific link to taxable transactions. If there's a specific link to an exempt transaction, 2 is not satisfied. Move on to 3. Because this is the modification. Alternatively, so if there is not a direct link to the taxable supplies.
So I really haven't understood that to be your proposition. So this modification is that if your direct immediate link is to exempt supplies, you disregard it here, do you? Is that what you
Well, it doesn't satisfy proposition 2, so you move on to proposition 3, my lady, yes.
Because 3 is alternative to 2.
Yes, exactly.
I understand that, but that's a larger modification, I think. We talk quite detailedly about the modification that you formulated for me was not in terms that you disregard a direct immediate link to an exempt transaction. I don't think, was it? It's about looking at analogous situations.
You do if the modification applies, and we see the modification in 4 reiterated. But the telling point is it doesn't say ask whether there's a direct link to taxable or exempt. It just says taxable, and then as my lady says in 3, alternatively, you don't have a link to a taxable. Do you have a direct link to the whole?
I just need to get this really clear. So you say 2 is an alternative reflection, if you like, of the modification we've discussed, which is that unless your direct immediate link is with a specific link, is with a taxable transaction, you go to 3.
Yes, my lady, perhaps rather than focus too much on 2, the answer is very clear in 4.
Should we do 3 next?
Well, 3 is just the direct link to your general activities. I don't think there's any controversial in that.
So that's what we've called stage 2.
That's stage 2, yep.
You're happy little 2 is stage 1, little 3 is stage 2.
Yep.
Is that right?
And then 4 is explaining where the taxable person acquires professional services for initial fundraising transaction, which is outside the scope. That use of the services does not prevent it from deducting VAT payable on those services, and retaining deduction if its purpose in fundraising objectively ascertained was to fund its economic activity, and it later uses the funds raised to develop its business. The same may apply if an analogous transaction involving the sale of shares is classified as exempt, SKF para 68. So, my learned friend, with respect, cannot explain that, because this is saying that if you disregard the initial use, if the purpose is a fundraising transaction that's to fund the economic activity. And my learned friend says you can never ever do that if the use is for an exempt sale of shares. Never ever. That's the chain breaking effect, which he says is never modified. But the Supreme Court clearly says, well, the same may apply. When may apply? When paragraph 68 of SKF is satisfied.
Why don't they, I mean, her point is, the language one, they talk about the same may apply. Otherwise, it's permissive. Or it might, it's possible. But on your case, it would apply. The same would apply, because that's the whole point of what you've been saying to us. You do the comparative exercise.
Yes, once you've gone through 68 and applied it properly, it actually would apply, yes, on the hypothesis. But look at the converse. It's one thing to focus on my case and say, well, couldn't on your case they could have said would apply. They could have said that. Well, look at my learned friend's case. It is impossible. It's not something that may happen. It's impossible in my learned friend's case that if you buy in a supply and use it for the purpose of an exempt share sale, that you will be allowed to then disregard that use and look at downstream ever. There's never any situation. So it's one thing to say, well, may is a bit more equivocal than it should have been on my case. I say they're just saying paragraph 68 and the conditions therein. But on my learned friend's case, this sentence should not be there. Or in fact, it should be the opposite. It should say the same will not apply. Why will it not apply? Because you've used it for the share sale and because that's exempt. And you cannot, my learned friend, with respect, cannot explain this sentence. She can make the point that it doesn't say would, it says may. Fine. But my learned friend cannot explain why the Supreme Court contemplates that there will ever be a situation where the goods are used, or the services are used for that initial supply, that you will ever be allowed to disregard that use. Her case is you can never do that. And this just ties in with, this is the 5th time now the the Supreme Court's made this point. Proposition 7, the purpose of the taxable person in carrying out the fundraising is a question of fact, which the court determines by having regard to the objective evidence. So there is a question of fact, my lord, but it's not where would the cost actually sort of fitted in the cash flow. And then it says the ultimate question is whether the taxable person is acting as such for the purpose of economic activity. So that's a factual question. And then finally, at 70, so the Supreme Court says on the facts of that case, yes, you can have recovery. And then at the end of 70, as my learned friends showed you yesterday, it says this may involve HMRC and more investigation than the CJU envisaged in BLP, paragraph 24, but that's an inevitable consequence of the Court of Justice interpretation. Now, my learned friend's case, as I understand it, was actually that is what everything up to now has actually been talking about, which in my submission is impossible. That's just not what they was talking about in the paragraphs I've shown you. I'm not going to repeat what I said. So just to reiterate that there is no, in my submission, whatever quibbles one might take with individual paragraphs, when you read the Supreme Court decision as a whole, and indeed SKF as a whole, there is no possible alternative interpretation that leads to my learned friend's conclusion. And there's sort of 5 fundamental points that my learned friend, with respect, cannot explain. And I'll just give you the paragraph references because I've already done this one. It's 41, called into question the ruling. It's 43, the Court of Justice disagreed with the AGO, and all the AGO did was, sorry, the Advocate General did was by chain-breaking effect. It's 46, the need to modify the result. What result? The effect of chain-breaking. It's 49. On the contrary, the reasoning from outside the scope has been taken across. What is that reasoning? It's the disregard of the initial transaction. And it's 65, propositions 2 and 4. Which I've just dealt with, I won't repeat that. So that is Frank Smart, and nothing in any of the other cases touches that. It's the Supreme Court, it's a detailed consideration, exactly of this case law, and exactly looking at these issues. Royal Opera House didn't consider SKF, not mentioned at all, cannot be authority on its correct interpretation, wasn't relevant. And that's what I'm saying, the danger of looking at non-fundraising cases and saying, well, look, that's still applying the normal test, doesn't help us. Associated Newspapers, paragraph 41, confirms the Court of Justice rejected the Advocate General's chain-breaking effect. Spader, it's about an outside the scope activity, fully considered by the Supreme Court, not relevant. Deutsche Bank, it's about fiscal neutrality and the interpretation of the clear words of an exemption. We have the Court of Justice telling us here what fiscal neutrality requires. It's not overriding the terms of the directive, it's interpreting its own case law about use and when you can attribute use to different things. It's not overriding the directive, it's not extending the directive. And we have this, the Court of Justice has literally told us what the answer is, and the Supreme Court's considered that. This is not a situation where I come to you with a fresh argument on fiscal neutrality and say, please change something that's previously been the case. We've got the Court of Justice telling us what the answer is, so Deutsche Bank is just irrelevant. And this is not isolated. There are a number of situations where the Court of Justice uses fiscal neutrality to achieve the right result in relation to input recovery. Another one is where a business comes to an end, and the costs of winding up that business are allowed to be recovered on the basis that the previous business activity was taxable, because to not do that would mean you can't recover the overall cost of carrying on a business, even though necessarily at that stage the taxable supplies have stopped, and you can't therefore be using the supplies acquired in relation to the winding up for those taxable supplies, because there aren't any. But the Court of Justice says, well, because it's a part of the process of winding up a taxable business. So these uses of fiscal neutrality are not isolated. It does happen to achieve the overall right result. And this is the overall right result. I mean, that's the point the Court of Justice is making, is the only difference between our case and a case where you definitely got recovery is whether you made management services. And that has very little to do with whether you should be able to recover the cost in relation to sale of the shares. In fact, it's quite odd, because the making of the management services involves making taxable supplies. And so, perversely, the making of taxable supplies means we can't recover VAT on the disposal of shares, where if we didn't make taxable supplies, we could. A man and friend tried to worry this court yesterday with scope and saying, well, what about the charity shop? What about the charity shop? The charity shop isn't making a disposal of shares, in my learned friend's example. The paragraph 68 of SKF, which is what this is all about, is limited to the difference in treatment between share sales. It has nothing to say about a charity shop.
Where would the line be drawn, though? Because everything that the CJEU seems to say is that, I'm paraphrasing a little bit, but come with me, that the unfairness is between a company that sells shares for fundraising purposes, which is a mere holding company, so it's outside the scope, and a company which is making some management supplies to a subsidiary. So that has an economic activity, and that brings it within scope, and then you have an exempt share sale on your hands. And what they seem to be saying is that the difference between those two scenarios is very slight. It's just a sort of happenstance that you're making a few management supplies.
Yeah.
But on your case, there's no space to look at the extent of the economic activity of the vendor company. And your case would extend even to a company that has quite an active engagement with its subsidiaries. You could say that Hotel La Tour has quite an active engagement with its subsidiaries because actually it's running the hotel business. So it's doing far more than just supplying management supply services. It's running a hotel business.
Well,
particularly if you take account of that grouping, which we've looked at that.
We're coming to that moment. It supplied certain managerial staff to the hotel company. I'm not quite sure how active in the scheme of things that would be. I'm also not sure why this is relevant. Because
can I ask you this question? Where is the fiscal neutrality line to be drawn? Because although there may be an argument that a mere holding company is quite like a holding company that makes a few management supplies, I haven't seen anything that says that this, this modification only extends where they're quite similar. What would stop this modification extending to really quite a wide range of companies that sell shares for the purposes of the business generally, for fundraising purposes? Wouldn't it be any company that sold shares for fundraising purposes, as long as the end activities of the company were taxable, would be able to get its tax back? Isn't that really the proposition here? So in other words, it's much wider than just a little...
Hang on. Holding shares in general is not an economic activity. No. We're coming to this in a moment because my own friend makes a point on it.
But if you're going to come to it,
deal
with it when you come to it.
But it's in a different context. It's only if certain things happen that it becomes an economic activity. Yeah. One of those things, if it's share dealing, which is where you're doing it on income account to make, that's not fundraising, that's just your business income generation from share transactions. That's not how my loan friend agrees. The other is where you actively manage the subsidiary. That's what the facts were in SKF. And then it talks about where the holding is a direct permanent extension. That I'm going to show you a case on that to show you what is meant by that. But it's only if one of those is satisfied that the holding of shares will amount to an economic activity.
But is it only the middle one? It's only the middle one, isn't it, that the CJEU is worried about? It's where you have got yourself into economic activity because you're providing management services. That's why they think there's a fiscal
Yes, and there's no, I can't see any basis for a distinction based on how the quantum of the management services you provide. And in SKF, it seemed to be quite active.
So all of that comes into the modification.
Yes, if you have a subsidiary which you actively manage, and then you sell that subsidiary to raise capital for the purpose of the wider taxable activity, you're within SKF.
But it wouldn't apply if you're selling the shares commercially. So the first
if you're share dealing,
share dealing doesn't apply. Is that right?
No, because that's not a fundraising activity.
No. And how about if it's a natural extension of your business?
We have to look at what that means. That's Reggie Dauphinois, where what that is intended to apply to. There, property letting managers received sort of advances from the property owners, put those advances into investments, and generated quite significant income from that.
My question to you is this: do you say that the modification needs to be subject to a further criterion, which is the litmus test, that if you don't permit recovery of overheads, you will end up with a fiscal neutrality problem because a sale of shares that's a bit like an outside the scope sale of shares will not have the right of recovery attached to it? Do you see what I mean? Do you have to test it, or is it just if you hit the fundraising button and you say it's fundraising, and if this had been outside the scope, there would have been a right of recovery, and that's enough to get us home?
There's no further criterion. The Court of Justice has already applied the criterion in telling us what the test is. So the test is simply paragraph 68. If this sale of shares is exempt because you did buy management services. Doesn't matter whether it was a little bit or a lot. That's never ever been suggested to be relevant by the court or the Supreme Court. Then you compare it to the outside the scope scenario, and that's the difference. And turning quickly then to the FTT and the Upper Tribunal. So all three judges that have considered this so far have agreed with myself. First Tier Tribunal, please, if we could look quickly at what they said in order to be accurate. So it's in the core bundle, tab 10. And at page, we have to do this very quickly in less time, but at page 1, 2, 3, the Third Tier Tribunal starts going through the authorities. And notably, the first authority it refers to is VWFS. Don't need to read that. But then at the end, 25, it is of note, as set out in 45, there is no need for the price of the tax transaction to be increased in order for the cost to be component of those transactions. So the criticism that the tribunal didn't understand that is frankly wrong. There's then further discussion of the cost component issue. At 31, the First Tier Tribunal draws out paragraph 65 of the Supreme Court as being the principles for fundraising cases. So that's actually correct. 34 is a summary of my learned friend submissions. Can I ask you to look at 34 sub 6, please? Ms. McArdle accepted during oral submissions that if the analysis reached stage 2, and so if the chain of attribution had not been broken, we did have a direct and immediate link to the general economic activity. That was accepted. So to try and suggest there might be some reason why that's not the case is not permissible. 35, we find there is a direct and immediate link with the downstream general economic activity and the chain is not broken. 36, we accept that the first stage of the analysis is to be modified in fundraising cases in the sense that with one right, the initial share transaction is to be disregarded. The effect of SKF and Frank A. Smart is that the relevant objective purpose is of the fundraising transaction. We've already been through that. 37, it is of note that Lord Hodge treated the Court of Justice as disregarding the use of the service in the additional transaction in fundraising cases. C38, that's the quote from Press Technic. 38, Lord Hodge treated the Court of Justice as extending the treatment of share disposal outside the scope to where it's exempt. We've seen that, 49. And then 39, when analysing the cost components, the manner in which the assets or services are paid for is not determinative. So the First Tier Tribunal is fully aware of the point. It's set out VWFS. It's summarised that point earlier, and it's made the point again at 39. Disagree at 40 with Ms. McArdle, saying that the general position is not modified. We've been through that. 41, we agree with Ms. McArdle's submission that an objective assessment is required as opposed to subjective. We also agree that the chain will be broken if the costs or cost components of fundraising. However, for the reasons set out above, we do not accept that the use of the services of the fundraising transaction prevents deduction. 43, we find objectively ascertained the purpose of the share sale was to fund taxable transactions. HMRC appear to accept that we're carrying out downstream taxable transactions. It then talks about the precise mechanics of the share sale and funds were used for this, that, and the other, and says it doesn't matter. And there's no appeal against that. So I don't know why my learned friend's bringing it up again. And at the end of 43, four lines up, this is because objectively analysed, the services were necessary to facilitate the share sale. 44, share sale does not prevent deduction. So, and then 46, we find that the cost of the services were not incorporated into the price of the shares sold. The agreed evidence is the shares were sold for the best price. Price was not increased. In the next sentence, we note in this regard that although there is no requirement for such an increased price or allocation in order for the cost to be a component of the price. So they're fully aware of VWFS. What they're doing is saying, well, even if we did take a more literal approach to this, you still lose HMRC. That's all they're doing here. They say, although there's no requirement for such an increased price in order for it to be a cost component, the presence of such an increase would support. And then it says instead they were paid out of the sale. But then at the end of 46, and this is the point that mattered, for the reasons set out above, the objective purpose of incurring the cost was in order to raise funds to pay for the downstream transactions. So they didn't make the mistake my learned friend says they did. They knew what VWFS says, they said it twice, and then they applied it again at 46. Quickly now with the Upper Tribunal, if I may, which is behind tab 6, paragraph 60. Mr. Justice Zaccaroli and Judge Brannan. So paragraph 60 on page 98. Clear to us that the reasoning and jurisprudence of the Court of Justice has evolved considerably since BLP. 61, far from restricting the right of input recovery to transactions within one, it's applied the principle of fiscal neutrality to extend the same treatment to what would otherwise be an exempt transaction. 62, Lord Hodge commented that subsequent decisions have called into question the BLP decision in light of its developing jurisprudence. Although not formally overruled, CGU never does as far as I'm aware, the BLP decision can no longer be regarded as representing a complete statement of the Court of Justice jurisprudence in this area. That's entirely correct. And as I said, it's notable that BLP wasn't even mentioned in SKF on question 3. 63, accept my submission that SKF was addressing the distinction between a transaction which is exempt and one which is outside the scope. And this distinction is one that arises, in Ms. McArdle's terms, at stage 1 and not stage 2. This is the point I've been banging the drum for all through this litigation. But my learned friend insists that there's a stage 2 issue. There's no stage 2 issue. And as the Upper Tribunal says, stage 2 is not concerned with whether a share sale is exempt or outside the scope. It concerns the general taxable economic activity. No matter how we read the decisions in SKF and Sveda and their interpretation by the Supreme Court in Frank A. Smart, we cannot give them the limited application for which Mr. McArdle contends. And that's true. It doesn't matter how you read it. It doesn't matter what quibbles my learned friend tries to pick in my interpretation. Her interpretation just does not fit. It cannot come out of those words. 64, Supreme Court noted the rejection of the chain-breaking effect. So this is 42, the Advocate General. 65, we agree with Mr. First's submission that the approach of the Advocate General is in substance the approach that HMRC urged upon us. That's still the case. I've made that point. That's still what they're asking you to do. Supreme Court rejected that approach. 66, instructed the National Court to determine this question by reference to whether the taxable inputs were likely to be incorporated in the price. And then it does talk about how the costs were allocated, which, yeah, it's not determinative. But the Supreme Court and the Court of Justice says, look at all the circumstances. But we've seen the FTT was very aware that's not the issue in the Upper Tribunal. At 68 specifically approves the FTT's reasoning. So at 68, we consider this passage correctly states the law, it discloses no error. Furthermore, we also consider the FTT's application of these principles to the facts in 41 to 46 is unimpeachable. 46 contains that recognition that you don't have to actually recover in the cost to be part of the cost. And at 67, I missed out. FTT correct when it applied what Lord Hodge referred to as the modified approach. 69, HMRC supplied the Swedish court decision in SKF. Do not find that to be of assistance, not in our judgment impact on the legal principles to be derived from the SKF judgment or from this mark. I would go further. I would say that it's inadmissible, and certainly of no persuasive value.
What's inadmissible?
The Swedish judgment, whatever. Swedish law would be a matter for expert evidence.
It's not inadmissible. It might not carry much weight. It's not inadmissible.
Well, in my submission, this court would be treading a very dangerous path if it starts saying, yes, it's permissible for parties to turn up with what it says are foreign judgments that in some way interpret a case.
We often get foreign judgments.
Well, interpreting the Court of Justice and saying, well, therefore, you should...
All sorts of different things. That's the point. You can make submissions about how it doesn't help very much. You're perfectly entitled.
Well, no, but the problem is we don't know what that is. We don't know what it represents, and we don't know whether it represents the state of Swedish law. For all we know, there could have been a decision by I don't know what level of court that is. For all we know, it could be equivalent to the FTT. No disrespect to the FTT, but it could be. And for all we know, there could have been a decision of a different court in a different case years later saying, well, actually, that's wrong. We just don't know, because my learned friend's not an expert on Swedish law. I'm certainly not an expert on Swedish law, and I'm not aware that there is any Swedish law expertise in this court that has looked into that question. So it just doesn't help us. What we do have, as I said, is frankly smart. The authoritative consideration by our Supreme Court of this case, the SKF case, and what it means. That's where you should look. Final point, my learned friend said, well, if I'm right, there should have been a partial exemption calculation because the share sale would be exempt. If HMRC wanted to raise partial exemption points, they needed to raise that in the FTT. Nobody's ever suggested that before, and it's wrong. It's wrong because when you're carrying out the partial exemption calculation, you exclude incidental transactions. And the reason you exclude them is because they distort the calculation. So, for example, if you had £500,000 of hotel sales in a period, and then you make a £20 million sale of a subsidiary that's an exempt sale, you don't then say, well, in our partial exemption calculation, we've got $500,000 of taxable and $20 million exempt, and therefore your recovery rate is going to be 5% or something. You don't say that. You exclude the incidental transactions. There's rules about that. And this will be an incidental transaction. So it's not a permissible point, and it's wrong. I've dealt with the charity shop. It just doesn't apply. And in any event, I don't even say how the problem arises, because if the charity shop initial transactions are taxable, then you get recovery based on the direct link to the taxable transaction and specific transactions. So I just honestly don't understand how the issue arises. Then we come on to the group argument, and I have to be very quick here. In terms of whether I should be allowed to raise it, I think the court has the point that pure points of law are normally allowed. My learned friend says, well, you didn't appeal the decision not to allow you to raise it in the FTT. First of all, I won. There's nothing to appeal. Second, my learned friend's misunderstanding the issue. The decision by the FTT was a decision that it was not appropriate to be able to rely on that argument at that stage in the FTT. It would be absurd if, in order to raise the new point on appeal, I have to somehow argue it's unreasonable for the First Tier Tribunal not to let me raise it in the FTT. Because that's what my learned friend's saying. He's saying, you should have appealed that. Well, in order to appeal that, I would have to come to the Upper Tribunal, or to this court, and say, the First Tier Tribunal was acting wholly unreasonably and not letting me raise it at that very late stage. Why should I have to say that in order to raise what is a pure point of law on appeal? It's just two different tests. So I can perfectly say, perfectly consistently, I'm not challenging the FTT's decision that was too late in the FTT proceedings. That was within the scope of reasonable decisions. Nevertheless, it is a point of law. Apply the normal test of points of law on appeal, it gets in. So my learned friend is misunderstanding what the decision is by the FTT, which was simply you can't raise it at that stage.
It would also paradoxically mean you've been in a worse position, having tried to raise in the FTT, even if you'd never thought of it at all at that stage.
I made that point in the Upper Tribunal. I mean, it's bizarre because you look at the cases, I think Altrad and Brown are in the bundle. In Altrad, it was a new Ramsey point that this court allowed on the basis of assumed facts. on HMRC's argument if HMRC had tried to raise that in a late stage of the Upper Tribunal and been told, no, you're too late for that. They wouldn't have been allowed to do in the Court of Appeal. Similarly, in Brown, it was a deliberate decision not to raise in the FTT, which they then decided, well, actually, we do want to raise it, and we're allowed. It's just perverse. And to suggest that if I kept quiet, I'd be okay, but because we tried to raise it and were unsuccessful. That's all I want to say on that point. So in terms of the argument itself, my first proposition is that apart from the VAT group, it was an exempt share sale because there was a supply of management services. There was a taxable supply. Important to understand here, and I'm not sure this was necessarily clear in my learned friend submissions, the existence or not of an economic activity is determined in relation to each holding of shares. So the fact that the holding company has an economic activity doesn't mean that its holding of shares is nevertheless, it's automatically an economic activity. So let's say there's a hotel business and we have a subsidiary that carries on another hotel business. If we don't actively manage that subsidiary, it's not part of an economic activity. And therefore, you can have situations, in fact, you will have situations, where some holdings of shares in a subsidiary are economic activity, and others held by the same holding company in other subsidiaries are not. And the case that makes that very clear is called Marlowe participations. I'm afraid it's not in the bundles, paragraph 46. But it says you need to look at it on a subsidiary by subsidiary basis. If you manage one, but not another, only the first one will be an economic activity, the second one will not. That's important because it goes to IMPA recovery. So just to focus this court's attention, it's the specific question is whether that holding of shares was an economic activity. Not did the company have somewhere an economic activity. Was that holding of shares? And it may or may not be. Proposition 2 is that the existence of that economic activity requires supplies and management services that are subject to VAT. So if we could look here, please, quickly at SKF. So it's tab 28, please. It's paragraph 30 for Court of Justice, which is on page. Page 425, please. So both sides, I think, have referred you to this, or at least rely on it. However, the court has held that the position is otherwise, so the holding does amount to an economic activity, where a financial holding in another company is accompanied by direct or indirect involvement in management. And then, after all the case quotations, insofar as involvement of that kind entails carrying out transactions which are subject to VAT by virtue of Article 2, such as the supply of administrative accounting and information technology services. So that might be relevant to my lady's question earlier about where's the line drawn, because clearly the court in SKF is contemplating quite a wide variety of management services. I'm not saying there's a distinction there, but anyway. Key point for present purpose is that the economic activity arises where you are involved in the management insofar as that involves carrying out transactions subject to VAT by virtue of Article 2. So we need taxable supplies. That's what it's saying. And that's why if you have taxable supplies in relation to one subsidiary but not another, the first one will be economic activity, the second one will not. What that means, therefore, is if you don't have taxable supplies, you don't have an economic activity in relation to that subsidiary. My learned friend says, well, I rely on only Northumbria for that proposition. No, I rely on the basic case law that says you need those supplies in order for there to be an economic activity. Northumbria just confirms the point. Could we go quickly to Northumbria, please? It's tab 18, paragraph 30. And that's on page 212, please. So tab 18, 212, paragraph 30. This is talking about MVM Magyar, which is a holding company case, whether the holding company was carrying on economic activity. There's the question before the Court of Justice of whether a holding company which played an active part in the management of subsidiaries, but which did not pass on the cost of its service in relation to those active holdings, could be regarded as a taxable person. So it did manage them, but it didn't do so for consideration. So it wasn't getting paid. And the Court of Justice in that case said, no, there's no taxable supplies there. Because although you're providing them with management services, you're not getting paid for it, you don't have taxable supplies. Because the definition of taxable person that raised the question of whether it was carrying on economic activity, in the course of the reasoning, the Court of Justice said, it follows from settled case law of the court that the involvement of a holding company in the management of companies in which it has acquired a shareholding constitutes an economic activity within the meaning of Article 9, where it entails carrying out transactions which are subject to VAT. 31, it would seem to follow that where a company is not carrying out transactions falling within Article 2, i.e. neither supplying services nor goods for consideration, is not engaged in the economic activity. That's a holding company case. SKF, holding company case. They're all saying you need these supplies, taxable supplies, within Article 2 to have an economic activity. The next point is VAT grouping. I don't think I need to show you it. It says in terms that the supplies, intragroup supplies, are disregarded. I don't think my learned friend disputes that the supplies of management services are disregarded. She disputes what that means. So that's section 43. My learned friend showed it to you. Well, before we even turn to Thor materials, my submission is a very simple one. We are told to disregard the supplies. The supplies are the only reason why we have an economic activity in relation to holding of shares. Following through our disregarding, there is no economic activity of holding shares. Put it in the opposite direction. If it said there is an economic activity, applying that case law, paragraph 30, you can go to 38 and 39, they say the same thing. Applying that case law, in order to have the economic activity, we need taxable supplies. How can we say there's an economic activity without having regard to the supplies? We've been told to disregard them. And the case law says, we'll see in a minute, disregard for VAT purposes, tax purposes. It doesn't say disregard it for certain limited administrative purposes. And that wouldn't work. That would have all sorts of bizarre consequences in terms of partial exemption, etc. if we didn't fully disregard these supplies in turn when it came to applying VAT. So my argument is very simple. The supplies are why we have an economic activity. We disregard the supplies. It logically follows there is no economic activity. More materials, please. Apologise for rushing through this, but I need to finish by past to get my learned friend the half an hour that I promised her. So Thor materials is tab 10. My learned friends explained the facts. Basically, there was a prepayment whilst grouped, and then the actual transfer of goods after you left the group. For your information, the prepayment is deemed to be a supply. It's not actually a supply without the deeming, but the prepayment is deemed to be a supply. It's the actual transfer of goods that's the supply in basic VAT analysis. Page 47, please. My learned friend's shown you this, so I can take it relatively quickly, but with different emphasis, if I may. So on 47, below by H, leaves open the question of what is meant by the requirement that you disregard the supply. Doesn't mean you disregard the separate existence of the appellant. So there are still two companies, fine. my case doesn't depend on there not being two companies, does not mean that the sale agreement or prepayment are treated as not taking place. That was the critical point in the case, that the prepayment wasn't treated as not taking place. And we'll see that in a moment, because what the House of Lords said is, whilst you were members of a group, you prepaid as to 90%. Put aside one side the grouping, that would normally be a supply as to the 90%. Applying the grouping, however, we disregard the supply. So there's no supply there, but it doesn't mean we don't recognize that you paid 90%, whatever that was in monetary figures. You did pay 90%. It just wasn't a supply. And that's why you fail, because when you come out of the group, you do actually transfer the goods. The consideration for that supply is what was paid for those goods. And we can see you pay 10% there and 90% there, put them together, you get 100%. So although we disregard the supply whilst in the group, we don't disregard the payment, and the payment then becomes part of the price of the consideration for the actual supply when you left the group. So that's critical. Prepayment not disregarded. And then it ends. What it does mean is that 90% supply to which the facts give rise must be disregarded or ignored for tax purposes. Not for some limited purpose, not for certain administrative purposes, for tax purposes. And you disregard it, you ignore it, it's all the same thing. Over the page 48, please, paragraph, the first substantive paragraph. Does it follow that the supply of goods to the extent of 90% is permanently excluded from the charge to VAT? I mean, that's slightly a possibly confusing way of putting the question, because all they're actually saying is, are we excluding the 90% of the consideration? And we see that in a moment, because actually that 90% supply is excluded, but it doesn't stop the 100% being consideration for the actual supply. Says, my lords, I can find no warrant in the 1983 Act for any such consequence. I accept Mr. Fleming's submission. They're not designed to confer exemption or relief, designed to simplify and facilitate by treating the representative member as if it were carrying on all the business of the other members and dealing on their behalf. Entirely consistent, the 90% supplies affected by those companies should be disregarded, so that the 90% supplies are disregarded for the purposes of the VAT Act. So we do disregard them for the purpose of the VAT Act, because they were not treated as carrying on their own businesses. That's also important. When we come to my learned friend's new argument, in this VAT world, with our VAT spectacles on, Hotel La Tour Birmingham has no business. It's not doing anything. The business is now at Hotel La Tour level, because that's the representative member. That's what it says there, that the subsidiary is not treated as carrying on its business, because the business is carried on by the representative member. In the next paragraph, we get to the reason why the taxpayer lost. They emerge into the VAT world as separate persons. And then this, the delivery of the goods by them to home undoubtedly constituted transfer of the whole property and the goods in the course of business. So undoubtedly was a supply. And once you've got a supply, the only question left is, what was the consideration for that supply? It constituted a supply of goods within the meaning of the legislation upon the amount of the consideration, whether already paid or still payable. And that's the key point, because we haven't disregarded, although we've disregarded the supply, we haven't disregarded the payment. And therefore, when we come out into the real world, we've got a supply of goods because we have an actual transfer. The consideration for that supply is whatever you've paid or prepaid. And because we haven't ignored the 90%, we now bring it into account and we get 100%. And so that tax scheme didn't work. But it doesn't mean we don't disregard the supply as the 90%. And then the House of Lords says, the appellant's objection to this approach disregards the fact that to the extent of the 90%, the supply was treated as taking place when the advance payment was made, must fail because this disregard, either disregard of the supply, treating it as not happening, is precisely what Section 29 requires. I mean, this is extremely clear that you do disregard the supply for the purpose of the VAT Act. And it's because you've disregarded that supply that you can then say, well, that prepayment just simply relates to that supply afterwards. So that's the majority. Lord Nolan, with whom two other members of the House of Lords agreed. Lord Hoffman was in the minority. Lord Clyde gave a concurring speech, which my learned friend did refer you to, but it says nothing different. No one else agreed with him, so he does say something different. You go with the majority, but he doesn't. So at the top of page 56, just between A and B, but the actual existence of such supplies is recognized, even although those supplies may have no VAT consequences. Well, we've just seen Lord Nolan say that they are disregarded. And frankly, saying recognize them, but saying they have no VAT consequences is the same thing, because my learned friend requires a VAT consequence. She's asking for this court to say, well, the VAT consequence of those supplies is that the holding of the shares is an economic activity. The only way she can get to that VAT consequence is by saying there are supplies, which is exactly what she's not allowed to do. Then, in fact, Lord Clyde goes on. Just above B, where Section 29 speaks of the supplies between members being disregarded, that must, in my view, mean that they are disregarded for the purpose of VAT, while they are members of the group and the single taxable person is the representative member. So His Lordship does recognise they're disregarded. And then he goes on, if the payment had been made when in contemplation of and followed by a sale and delivery to home while both companies were still within the group, supply could be treated as occurring at the date of the payment, to the extent of the payment, although that would be academic because the supply would be disregarded for the purpose of VAT. So read it as a whole. The end result is very clear. You do disregard it. Any attempt to rely on a supply is academic. It doesn't help you. You can't rely on the VAT consequence. Quickly on disregard versus not a supply. So my learned friend says, well, the VAT legislation's primary legislation said disregard the supplies. There's a Treasury order from 1992 that treats it as not a supply. That's a very important distinction. Well, the VAT legislation comes first. It's primary legislation. The Treasury order, drafted by the Treasury, laid before Parliament, if it uses different language, so what? It doesn't change the meaning of disregard in the VAT legislation. It takes us nowhere. Intelligent managed services, just a very different question. The Court of Justice says at 29, you need to ask whether the transferee intends to operate the business or liquidate it. That's the only question it asks. And at 50, the Upper Tribunal specifically says the VAT effects of supplies are disregarded. Now, whether it fully understood what that means in terms of economic activity is sort of neither here nor there. It's not binding on this court. If it got it wrong, I'm not saying it got the result wrong, but if it misunderstood how that operates in relation to these facts, which it wasn't considering, then that's neither here nor there. But it specifically confirms at 50 the VAT effects of the supplies are disregarded. One VAT effect of these supplies is that the holding company is treated as carrying on economic activity. Disregard that VAT effect, my learned friend can't get home. Finally, my learned friend's new argument. I don't object on time, I just object that it's wrong. The argument seems to be that even without the economic activity of managing a subsidiary, well, Hotel La Tour is still carrying on economic activity. Well, that's true, but entirely irrelevant for the reasons I explained. It's not enough that the company that owns the shares has an economic activity. It's the holding of shares itself that needs to be an economic activity. HMRC referred to harness. We can just quickly look at that. This is the last thing I will do, and I'll do it as very quickly as I can. It's page 311. It must be tab 23, please. So on page 311, at the bottom, we've got 14 and 15. If maybe the key point about 14 is it emphasizes the need to be obtaining income from the property on a continuing basis, and that's carried through in 15, at the top of 312. The court has also specified the mere acquisition and holding of shares is not to be regarded as an economic activity. Mere acquisition of a financial holding and other undertakings does not amount to the exploitation of property for the purpose of obtaining income therefrom on a continuing basis, because any dividend is merely the result of ownership. So the concept of an economic activity is the obtaining of income on a continuing basis. That's what you need. So just to say, well, you are a holding company, you have an economic activity, and you have shares in a company, doesn't answer the question of whether that holding of shares is part of an economic activity of itself in the sense of obtaining income on a continuing basis as a result of owning that property. As I've already said, in this case, HLTB, Birmingham, doesn't have a business. The business is treated as up at Hotel La Tour.
Well, this is what I'm finding a bit difficult about this point. There's no doubt that under section 43(1), if there's a group situation, the business of each member of the group is treated as carried on by the representative member, which in this case is Hotel La Tour. So Hotel La Tour is, for VAT purposes, to be regarded as running the Birmingham Hotel as if it owned the hotel itself.
Yes.
When it decides to dispose of that economic bit of its operation, in the real world, what it does is dispose of the shares.
Yeah.
But in the VAT world, what it does is it closes down its business and disposes of that business. Now, the mechanism by which it does that, because the HLTB is in fact a separate company, is disposing of the shares. But in the VAT world, it's treated as if it had simply sold a hotel. Now, if it had simply sold the hotel in which it had been operating, that would be a taxable transaction as part of its economic activity, wouldn't it? So why does it make any difference when what it's doing is selling the shares, which is how in fact it is treated as carrying on its business?
Well, it shouldn't make any difference. And in that situation, the sale would either be an outside the scope transfer of the going concern, full recovery, or it'd be a taxable transaction, full recovery. So it's just that my learned friend, it is a technicality. They're relying on, well, technically it's by way of shares. Technically that's exempt, and I'm saying that's wrong. But my lord's right. I mean, in the VAT world, you've gone from owning a business to not having a business. Is that a transfer of going concern? But the overall point is that there should be no difference in the outcome. And this argument leads to that correct result, because there is no economic activity in relation to holding the shares, so we end up with the same result. So
you say that even though it's treated as carrying on the business, the hotel business in Birmingham, it's not carrying on an economic activity in holding the shares, and it's only the holding the shares which brings the subsidiary into the group, which means it's carrying on the business. I have some difficulty with that. If it didn't hold the shares, it wouldn't have the business in Birmingham.
Well, it wouldn't be treated as, but that's just because of the way the deeming rules work. But in terms of an economic activity, we're seeing here, an economic activity requires the obtaining of income on a continuing basis, in this case from that property. Hotel La Tour is not obtaining income on a continuing basis from the subsidiary. But it doesn't even, I mean, in this hypothetical world, it wouldn't even get dividends, but what you need is supplies for consideration, the obtaining of income. And in this hypothetical world, there is none, because there are no suppliers of management services for consideration, and there's nothing else. And that's the point I'm making it when coming to a 16, because the court tells us, this is the point I started making earlier, and I appreciate I'm over my time, so this will be super quick. Paragraph 16, it is true that the transaction referred to in the exemptions for shares may fall within the scope of VAT where they are effected as part of a commercial share dealing activity. That's one. No friend agrees that's not us. In order to secure a direct or indirect involvement in the management of the companies, we've seen what that requires. It requires taxable supplies. I've argued that's not us. And then third, or they constitute the direct, permanent, and necessary extension of the taxable activity. And that's what my learned friends seem to rely on. The example for that is Reggie Dauphinois. You can see that. And I just wanted, as the very last thing I do, show you what that case was about to illustrate what the court is talking about here. It is talking about obtaining income on a continuing basis. And fortunately, the Advocate General tells us what the case was about at 305 in the same tab, I think. And I already briefly explained what it was about. Paragraph 38.
Sorry, where are we?
So same tab, still Reggie Dauphinois, but Advocate General.
We're not in Reggie Dauphinois.
No, but it tells us what happened in Reggie Dauphinois.
Okay. So where do I go?
Page 305, my lady, paragraph 38. So that's the facts. The facts were that it was a property management agent. It received advances from the owners of the properties, and it deposited those and made investments with those. And then what the court said is, and you can see this in 39, in the quote, in the case at issue in the main proceedings, the receipt by such a manager of interest resulting from the placements of money received from clients in the course of managing their properties constitutes the direct, permanent, and necessary extension of the taxable activity, so that the manager is acting as a taxable person. So they were doing something that was producing income on a continuing basis. Why was it a direct and permanent extension? Because the money they were using came from their role as property managers. That's what that's referring to. It's not the sort of broad, unanchored analysis my learned friend says. We'll just ask in general terms whether you think this is a direct and permanent extension. And even if that was the test, the holding of the shares was not a direct and permanent extension. It was holding of shares in a company that had no business, and which you didn't manage. I apologize for going 4 minutes later than I expected, but unless the court has any questions, those are the submissions.
No, thank you very much, Mr. First.
Thank you.
Yes.
May I begin with answering Lady Justice Whipple's question approximately an hour and a half ago of what the modification is from what was said by the Advocate General and SKF to what is said in the judgment, which is picked up on in Frankly Smart. Could we start, please, in the authorities bundle? It should be the second hard copy volume, tab 28 at page 420. Touched on this yesterday, but I'd like to make it entirely clear. So we should be in the Advocate General in SKF, page 420, at the bottom of the page, paragraph 89. And we see here the set of conclusions that the Advocate General reaches on the facts of SKF as to how it should be resolved. The reasons set out above, I propose that the court answer the questions referred as follows. 1 and 2 are not relevant to the particular question here. 3, a taxable person who has acquired supplies of services in order to carry out a disposal of shares in a subsidiary and in a controlled company, a transaction which is covered by exemption and with which those services have a direct and immediate link, does not have the right to deduct input value-added tax on those services, even when the disposal of shares is a transaction which contributes to the objective of restructuring the taxable person's activities. Now, I will make it good in a moment, but what I say is, first of all, that is the very specific subparagraph that Lord Hodge says the CJU does not quite agree with. And what is missing here, it's not so much that that is wrong, it's that two-stage analysis that the CJU, and for that matter, the Supreme Court, repeatedly says that is what you need to do. Because here, the Advocate General has, like Mr. Firth, I say, incorrectly concluded that the facts found are clear enough that we know where the direct and immediate link lies, and therefore a conclusion can be reached as to the recoverability of the input tax. And that's what CJU doesn't agree with. If we could look please at Franke Smart, just to make that good, page 184, please, of the authorities bundle. I think that would be volume 1, apologies, I haven't written that down.
Yes. Tab 16.
Thank you. So we've looked at this before, we're in Franke Smart, paragraphs 42 and 43. And I take the court to that because that's where we see the passage that was read this morning. At D, he, the Advocate General, opined, point 89.3, what we just looked at, goes on to say essentially, read, paragraph 43, the CJU disagreed with his conclusion in relation to an exempt transaction involving a sale of shares in circumstances which were analogous to the facts of the case and held, paragraph 73, that there was a right to deduct input VAT paid on the services acquired for the purposes of a disposal of shares if there is a direct immediate link, etc., the downstream activity. Final sentence, last few lines, it held that the referring court should take account of all the circumstances surrounding the transactions to determine, etc., where the direct immediate link lies. So that is where the CJU differs from what's said by the Advocate General. And it absolutely agrees with what's said in paragraph 89.3 of the Advocate General, in paragraphs 59 and 71 that we've looked at before, if we get to the point where the direct and immediate link is with the exempt share sale. So that's the modification that the CJU takes.
Is it just a modification of process then? Does it make any real difference to outcome? Because if that's right, it's saying, look, you can't assume either way.
Yes.
We discussed this yesterday. You've got to go through the proper process of finding where the direct and immediate link lives, attaches to, and that's a question of the national court taking account of all circumstances. But I suppose the point against you is that's all very well, but that amounts to, that's not a hill of beans, really, because if you're always going to say, there's always going to be a direct and immediate link between, let's say, marketing costs and the share sale. So why does it make any difference? Why did the European Court bother going there?
Because it does make a difference. There isn't always, it's very important to say, there isn't always a direct and immediate link between those sorts of costs and an exempt share sale. Not only does the CJU say it couldn't untangle that on the facts, as a matter of fact, in the SKF case, some of the costs, there was insufficient evidence for the Swedish court to unpick where the direct and immediate link lay at all.
Could you give me some examples? Could we have there's some examples that we can find in the case law of where some of the costs are not attributable to the share sale, or there's a question mark about that?
So I can certainly go away and look at, I don't think there is a specific example relating to a share sale, but I'll have to
Can I dig further then? As a matter of fact, in SKF, some of the costs were insufficiently evidenced.
Yes.
Keep going.
So we can look at that. That is, wait a moment. In the second volume of the authorities, right at the end, almost, apologies, page 562. This is the Swedish court's determination, and I've already made reference, in fact, I think to both of these sections. The one marked with red is the finding that these specific costs are directly immediately linked, so that was writing of contracts, legal services, sorry, I missed the first one out, negotiations with acquirers of the shares, Second paragraph, on the basis of the existing information, it's not possible to determine the extent to which SKF is entitled to deductions in respect of services other than those mentioned. And if we go back, perhaps page before.
It's the paragraph at the top of the page, isn't it? There's a supplementary letter mentioning financial due diligence and remunerations to market participants.
Thank you. Yes, those are examples. So it would be anything which fails, has a connection to the sale of shares, but fails to meet the Mayflower, BLP, Royal Opera House test. So the examples would include even things which, if they were a single supply, would be directly and immediately linked. So for example, if there is legal advice on how to perform a share sale, if that's a single supply of that legal advice, normally, you would expect it to be directly and immediately linked to the exempt share sale. But it wouldn't be if there is a single supply that is much wider than that, that say covers all sorts of legal advice about restructuring, and one element of it happens to be advising on the share sale. It's a single supply, but you don't get your direct and immediate link, and you may get a direct and immediate link to general business activity. So it's that kind of input, that kind of cost. It's very commercially normal, but for costs as well, like the Midland Bank situation, again, arise out of, relate to, in the words of SKF, the share sale. But you don't get a direct and immediate link to that exempt share sale. So it's that kind of input. Any, so the sort of composite supplies, as I say, where you might even have the share sale facilitated by that supply, but only by an element of it. And overall, it is something else that can't be directly and immediately linked to that share sale.
So you say it's not purely notional. I mean, there really are costs that might
absolutely
come within this, we call it modification.
Yes, yes. There could be, on the but-for analysis, for example, there could be the share sale, and advice before or after could be obtained from accountants and lawyers, for example, on all sorts of fallout consequences, so contracts that need to be renegotiated or various restructurings that need to take place, funds that need to be diverted to somewhere else, bank accounts that need to be changed. There could be all sorts of but-for costs that relate to a share sale, but that are not directly and immediately linked to it. So, Mr. Firth.
I was just going to get back to, can I just bed that one down? Sorry to make this. I think this is the guts of the case, so I'm quite interested to get this straight in my own head. Going back to the AG in SKF, where he said, he was too bland, was he, 89.3, he was too generalist.
Yes.
He made an assumption he wasn't entitled to make, is that right?
Yes, he thinks that from what has already been determined, he can say the direct and immediate link is with the exempt share sale.
On what I've seen so far, it doesn't matter to me that the speech court seems to have got itself in a muddle and made lots of findings. I can be satisfied that A plus B equals C, and I put it in the exempt category.
Yes.
And that's, so my question to you is, what's the modification of result that Lord Hodge is referring to? So let's go to that. Anyway, I don't take you off your course. So that's the point where there's a disagreement, you say.
Yes, and exactly. So, and the modification of result is only to the extent of SKF, paragraph 68. While we were, may I ask, my lady, where you are? You've been frank, because I was going to deal with everything in frank first, but if we're in SKF, we should deal with everything in SKF first for time. Right. In that case, then, so, it's probably best for timing simply to skip straight to SKF, because most of the points I want to make relate to that. Could we start then, please, at page 424, tab 28, page 424. This is in the judgment. And I take you to this page because paragraph 21 is significant. Under B, just under B, the reason for those disposals is to obtain funds to finance other activities of the group. So I draw the court's attention to that factual finding, because the factual finding, the relevant one, that was not confusing, was not ambiguous, was not something that the domestic court failed adequately to assess, was the reason behind the share sale. And consequently, the court has this point, but I'd like to reinforce it. Given that the CJU knew that, if that determined the outcome, there would be a paragraph saying, because that is the reason, that therefore leads to the outcome that the direct and immediate link lies with the downstream taxable activity, if Mr. Firth's analysis was correct. And it doesn't say that anywhere. It says, effectively, Advocate General's approach is too bland, you need to go back, or too simplistic, you need to go back, you need to perform the ordinary two-stage test. Direct immediate link, is there a direct immediate link to the exempt share sale first? Then we get paragraph 59, paragraph 71, which say, if there is without qualification as to the reasons behind it, that means no input tax recovery. So, page 430, please. Apologies, actually, page 429. I took the court yesterday to paragraph 54, but I'd just like to underline again what's said there. This is the court explaining its understanding of one of the questions. By the third question, the referring court asks, in essence, whether there is a right to deduct input VAT pursuant to legislation on services required for a disposal of shares on the ground that the costs of those services form part of a taxable person's general costs. So it knows, and it sees no ambiguity in relation to whether or not the reason behind them was, well, on the ground that the cost of those services form part of the general person's cost. It has in mind that there's already been a finding because of the reason behind it that they are, but it's a contradictory finding. And so everything that comes after is trying to help a national court that has got in a muddle. Hence, what we see at 57, 58 is all straightforward, very well-versed law, nothing new there, explaining that in relation to taxable transactions, either specific or exempt, if that's where the direct and immediate link lies, then there's recovery. 59, as I say, without qualification, is telling us that if the direct and immediate link is to an exempt transaction or an outside the scope, there is no recovery. The end of 60, we see the incredibly obvious and straightforward, but needing to be spelled out here because of the confusing background of what the Swedish court did, the two-stage test, whether, in either case, whether there is a direct immediate link, is based on the premise ... that's a G. 61 we've gone through. That's the cause of all the confusion. In that regard, at 62, there's, although Mr. Firth keeps saying, there can be no alternative. That is a mischaracterization of HMRC's case. The CJU is saying here, it's confused, it can't unpick this odd set of factual findings, which cannot be reached if the tests are properly applied, and therefore there's a need to engage in the two-stage process. And it's either or. That either or is incredibly important and ignored really by Mr. Firth. So when we get to 64 to 68, we see the fiscal neutrality problem. Now what we understand the court is doing here, 64, in order to give a useful answer, so it said, well, the court hasn't found where the direct immediate link lies, so we can't unpick that, and therefore we're going to try to predict what might go wrong or what might be helpful going forward. Mr. Firth repeatedly says there could never be a fiscal neutrality problem at stage 2, but of course that's untrue. The mistake could be made in which the domestic court sees that there are, for example, costs on a but-for basis, or costs that have a relationship with an exempt share sale, even though there's no direct immediate link, and therefore shut out the possibility of a direct immediate link to the general taxable activity. That's the fiscal neutrality problem. We know that because, for example, if it was a problem for fiscal neutrality to treat exempt supplies differently, paragraphs 58 and 71 wouldn't say unambiguously no recovery of input tax. And because 68 and earlier paragraphs 2 says, this is the heart of the case, says if the consultancy costs relating to, not directly immediately linked to, relating to disposals or shareholdings are considered to form part of the taxable person's general costs, then the same tax treatment must follow. Whereas Mr. Firth rewrites that, and that's the whole of his case. He says that, we say, the same tax treatment must follow, which means you have to treat the direct immediate link as fallen with the general costs, and that's wrong. It's not the wording, it's not what the Supreme Court says, it's not what the CJU is saying here. So there isn't much of a modification of result, but there is modification, or there is comment on one of the possible feared ways in which the domestic court might go wrong, which is, as I've described, treating where we have only direct immediate link with the general costs, paying any regard to something else that's not directly immediately linked. Because those are two, for fiscal neutrality, similar supplies, two different businesses with taxable general costs, equally using an input. That input has to be treated as recoverable in both cases. It would offend fiscal neutrality without. Mr. Firth has not been able to point to any actual example of a fiscal neutrality breach at stage 1, because a difference in treatment is not a breach of fiscal neutrality. It's only a breach of the
Isn't that what he
supplies.
says is happening at 66? Isn't that what he says the court is pointing to there? Is the idea that you don't allow recovery of these inputs, where you would allow them if you had somebody who wasn't making a stage 1 exempt supply, then that is your breach of fiscal neutrality. That's a sort of stage 1 point, isn't it?
But only if the direct immediate link lies with the general costs. Paragraph 59, paragraph 71. Fiscal neutrality can't knock down walls in the directive. An exempt supply using an input is not similar to something else using the input. And that's really the complete answer. He requires multiple paragraphs of the authorities to be rewritten or new words added in or possibly deleted in places in order for any of it to make sense. Very quickly, I think the court really
So
already
the
has my
modification of results is paragraph 68.
Yes.
And the result is that it's a very slight modification, actually, isn't it? It's a tiny modification. It's just it's really more like a sort of restatement or
Yes.
adjustment.
I see it as best described as the CJU predicting a way in which the National Court might go wrong.
So it's trying to stop them going to the elephant trap. It's saying,
Yes.
Yes. Right. Okay. Thank you.
Yes. I think the court already has the points really I would make in relation to over the page, paragraphs 72 and 73. We have gone and found securenta because there were questions asked about it yesterday. We thought it might be helpful to see that what's... Perhaps we can hand it up. Thank you. Can I ask Mr. Walker to approach and hand those up? Very, very briefly. But the point I would draw is that paragraph 72 is saying, in the second half, you will only get, thank you, a direct and immediate link with general costs if that's the only place where the use is. And the paragraphs 28, 29 and 30 of securenta essentially say that same thing. So, of course, I take it that it's dealing with how do we unpick partial exemption. But my position would be that it's interesting that it's first getting very well.
It's not partial exemption.
All right. It's dealing with a different set of facts, but the paragraphs that are being referred to again stress that there can only be a direct immediate link in one place. So that again would be not what we would expect to be said if the effect of SKF is to rewrite the rules and say if under the ordinary direct immediate link test, you can have...
I seem to be handed 4 different things, but only 1 copy of them.
So essentially, the paragraphs that are being referred to,
28 and 29.
28 and 29, are, and 30 as well, although it's not referred to there, but I'd ask you to read that, are referring to the possibility of a direct and immediate link only in one place.
One minute, I'll read that.
What do you want us to take from these paragraphs?
That it's notable that in SKF, a case about exempt potential direct and immediate links with an exempt transaction, that these paragraphs, which stress again that there can only be one direct and immediate link to in a
I
complete
thought
unison.
what this was going to do, can I put it in my words? Can you tell me if I've misunderstood it? All this is saying is that even if you're at stage 2 and you're saying, let's look at what the overall outputs of the business are, you've still got to ask yourself, are those outputs all taxable or just a bit taxable? Because securenta, it was a mixture. Some of them were outside the scope and some of them it looks like were within scope. I don't know if they were taxable or exempt. And all it's saying is you can't get, even if you're at a stage 2 analysis, you can only get back a proportionate amount that equates to the proportion of your general outputs that are taxable outputs, but not to the extent they're not business activity at all. So you've still got another sort of apportionment thing to go. So it's not partial exemption, strictly speaking, but it's something similar. It's saying you've got to work out how much you're entitled to.
Yes, it is. Paragraph 30, which I accept is not cited in the judgment, but is of some significance too, in that it's saying essentially, even if the activities are non-economic, then you can't, if that's where the direct immediate link lies, then you can't get around
You don't get them back.
So my point isn't so much that it says something profoundly surprising or interesting, but that it isn't what you would expect to be being cited if this profound change in the right of recovery or non-right of recovery where there is a direct immediate link to an exempt transaction is in play. If that was what the court was doing in SKF, it wouldn't be citing these ordinary principles about when you can and can't recover, is all I was referring to. I have handed up a few documents. I'm conscious of the time. May I?
How much longer do you want to be?
I think 5 minutes, subject to questions.
Yes? Okay, well, 5 minutes.
I have very, very little left to say. Frank Smart, I won't go through in any greater detail. You have my submissions already.
I'm afraid I have a few questions on Frank Smart. So can we go there?
Please, yes. So, for example, pick up page 185 as paragraph 47. I'm not sure where.
I think just wait for the questions.
I wanted to know, and I'm afraid I've failed to note down paragraph numbers that it attaches to. So, yeah, let's go to paragraph 41, which is where we started this morning. I think you haven't got any quibble with 41. CJU has called into question its ruling in light of developing jurisprudence, and then we see the cases. And we talked about 42 and the AG, 89.3. 43, the CJU disagreed with this conclusion. Do you, is Lord Hodge right to say the CJEU disagreed with this conclusion in relation to an exempt transaction involving a sale of shares in circumstances which are analogous to fact case, a lot of weight is put on 43. And what I wanted to know from you is whether Lord Hodge is right. Do you agree? Is he right to say that CJU disagreed with what the AG said?
I think he's right to say it was a disagreement that was how the case should be resolved, because it's paragraph 89.3 of the AG, which the disagreement is described as particularly being focused on. So it's a disagreement about the conclusion as to what the National Court needs to go away and do. But I don't read any disagreement as to fundamentally, if that's where the direct immediate link is, then there's no recovery. And we see that, as I say, in the two paragraphs I've over and over again referred to in SKF, but also paragraph 47 of Frank A. Smart. So just slightly further on, I've gone to this already, but at the end of this is a passage where the Supreme Court is saying it acknowledges very clear indication that there's no recovery if the direct immediate link is with the exempt specific. And the words, unless the cost of the inputs was a component of the price of the shares in the digital transaction, say to us the beginning half of paragraph 71 of SKF, i.e., here is the Supreme Court saying, of course, if that's where the direct immediate link lies, then there's no recovery. And that's one of the passages which Mr. Firth's analysis can't survive because.
Can I ask paragraph 40? I think I've got that point. Paragraph 46. Mr. Firth places in significance on the all of that paragraph,
yes,
particularly the bottom bit, where Lord Hodge says that it's implicit. So this is actually the only bit I think of Smart where you see any sort of interpretation or gloss being put on SKF. Otherwise, all that Lord Hodge seems to be doing is just setting out bits of it.
yes.
But here he says that he thinks it's implicit in the court's reasoning that having accepted the chain-breaking distinction, but it recognised the need to modify the result. So the modification of result, we talked a lot about that this morning. What's he talking about there? Because on your case, there wasn't really any modification of result. There was just a telling of the National Court to go and do the job that we all know it should have done, and it was open to the National Court to decide that this was a stage 2 case. So what is the modification of result that he's talking about there? And is he right?
It can only be modifying the result if the National Court does what is said in 68 of SKF, which is if it makes the finding that the direct immediate link lies, and it can only lie, solely lies with the general business activity, then the CJU and SKF is saying you cannot have a fiscally non-neutral result because you've got a taxable general business using an input if you were to fall down the rabbit hole of finding that the mere connection to, but for connection to, or economic connection to the sale of shares meant that there couldn't be recovery. Because I appreciate it's not much of a modification, no, but that is as far as the plain wording of SKF goes. And in particular, Mr. Firth's, we say, profound change of the rules of that can't survive paragraph 71, no, which doesn't contain any such qualification.
But it might therefore follow that Lord Hodge has read a bit too much into SKF in your case, hasn't he?
Only in the sense that the word modify is there, but I'm not going to say that Lord Hodge is wrong. It is perhaps not the word that I would choose to use, but our reading doesn't involve adding new paragraphs and new lines in the way that Mr. Firth does. So that's as far as we would go. The only other thing I wanted to say specifically about Frank A. Smart was about paragraph 65. I've said it already, but it's only addressing the facts of the case, and it says that in its introduction. Those are the principles applicable there. It's really important to bear in mind that it's not a case where there was a potential exempt specific transaction that could have directly and immediately been linked, and that's why on the facts of that case, it then goes through, I think it's paragraphs 2 and 3, where it says we just need to look for a taxable transaction that might be using the inputs.
And then 65.4, which was my last question.
65.4.
The may, the word
yes,
may, which again is
yes,
significantly emphasised
yes,
by Mr. Firth. You say, well, question to you, but I think you say that the may is picking up the modification, that's all it's doing, it's saying there are circumstances where
yes,
you may get to stage 2.
correct.
Okay, thank you. That's all I wanted to ask you.
How are you doing?
I have almost nothing left to say, I think. those behind me to make sure any post-its come up now, if there are any. I was going to say a few things about the facts of the case, but I don't think material I have anything to add to yesterday about the approach. You already have my paragraphs in relation to what the tribunals actually decided.
I don't think you need to repeat anything. In fact, I think you need not to repeat anything.
I will endeavour not to repeat anything.
Just if there's any new points arising out of what Mr. Firth said.
Mr. Firth this morning has addressed, of course perfectly properly for the first time, my new argument in relation to economic activity. We say, well, there clearly is economic activity in operating a hotel in Birmingham. Clearly, the ownership of the shares is subservient to that economic activity. It's a completely active type of share ownership, arguably more active than simply providing services of management, which might not be the complete management services. It's operating in total. It's economic activity on that analysis.
Yes.
You already have my passages in relation to everything else. The only other new documents we've handed up, very briefly, they are, you asked yesterday, my lord, in relation to anything about the meaning of cost component or incorporating the price.
Article 1 and 2 of the current Principal VAT Directive.
So I think we've supplied that in the first. There is no definition of cost component.
No.
But it is used in the articles which we have provided you with. I think 1, 2 of the current and in Article 2 of the first.
Yes.
And we were also asked if there are any cases which we've missed, as it were, if there was a flurry of activity around 2009 or after. The only case which we've added is one that's been referred to in the tribunals in this case, TLLC, which considered remarkably similar facts. We didn't initially include it because it is a tribunal decision, so of course it's not binding. If I could just give the paragraph references perhaps, so you can see, so paragraphs 2 to 5 are the facts, which are very similar to here. Paragraph 9 summarises the questions and the answers. And paragraphs 140 and 205 to 209 show the tribunal, we say, essentially coming to the same understanding of SKF and its application where there's an exempt sale of shares as our understanding. There hasn't, final point, there hasn't been any guidance issued on SKF. It wasn't presumably considered to have changed anything enough for HMRC to issue guidance, but we have included a section of the internal manual that comments on it, albeit at the very top with the caveat that it doesn't say everything about the case, it's just picking up one point. And what's actually said about the case really touches on the definition of economic activity. It doesn't tell us how to resolve whether or not the exempt or the general is where the direct and immediate link lies, beyond saying the court or the tribunal has to resolve that question. So it's not really focused on the main point in this case. May I turn around just to make sure that there isn't a message urgently? In that case then, I'm sorry I've taken about 7 minutes. Unless there's any question that I can assist with further, that's my reply.
Thank you very much indeed. Now, Mr. Firth, did you want to say anything about securenta?
No, my ladies understood exactly what security is.
Well, thank you.
I got something right today. That's good.
Thank you both very much. I think I can speak for all of us when I say that the submissions have been of very high quality on both sides, and we're immensely grateful for all the help we've received. You won't be surprised to hear that we'll be reserving our judgments. We will circulate them in draft in the usual way. As you will be aware, they come with an embargo, which means what it says. And the draft judgments is an opportunity for you to correct our typographical, spelling and grammatical mistakes, but not to seek to correct our reasoning. If you can let us have an agreed list of any corrections, and if possible an agreed order, or if disagreed, draft showing where the disagreements are with brief written submissions, we'll deal with that on paper, and then we'll hand down judgment remotely in the way that is now almost universally adopted. Unless there's anything else, thank you both very much.
All right.